Good afternoon. My name is Sarah Thoemke, and I am a human resources consultant, and I've been doing human resources for a very long time, but I've been a consultant for about the past 12 years. And Vivian asked me to come. We've known each other through a human resources group we belonged to a few years ago. So Vivian asked me to come and do some sexual harassment training with you. So if at any time you have questions, please feel free to ask. This isn't terribly formal. And I want to start off by asking you, when you hear the term sexual harassment, what comes to mind by those words for you? Okay, good. Anything else? The term has been around for a very long time now. So most people, I think, are familiar with the term sexual harassment. And I'm going to give you some legal terms and definitions for a couple of minutes, so just bear with me. By definition, sexual harassment is any unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. Now, this is the really legal definition. Submission to such conduct is made either explicitly or implicitly a condition of employment. Submission to or rejection of sexual harassment of such conduct by an individual is used as the basis for employment decisions affecting such individual, and such conduct has the purpose or effect of unreasonably interfering with work performance or creates a hostile or offensive work environment. Any questions about that? So what that means, basically, is if, as an employee, for example, a supervisor or another employee comes up to you and says, for example, if you go out with me, then I'll make sure you get promoted. Or if you don't go out with me or have other sexual kinds of relations with me, I'll make sure you get fired. So that's what this statement means. In 1986, the Supreme Court upheld that sexual harassment is a form of discrimination under Title VII of the Civil Rights Act of 1964. So that means that if you feel that you have been subjected to sexual harassment, you may file a charge of discrimination with the EEOC. There are two kinds of sexual harassment. One is called quid pro quo sexual harassment, and the other is hostile work environment. So quid pro quo means something for something. If you do this, I'll do that. If you go to bed with me, I will do this for you. This kind of sexual harassment is extremely difficult to prove, and we'll talk about this in a minute, but if a supervisor conducts quid pro quo sexual harassment, the employer has no legal defense. In other words, the employer is strictly liable for the actions of that supervisor. And hostile work environment means really everything else. So somebody had mentioned jokes, inappropriate comments, inappropriate touching, things that make going to work for somebody or a group of people very difficult. Okay, quid pro quo is when a supervisor threatens a term or condition of employment which results in adverse employment action and has tangible job detriment. So in other words, that just means that the employee who is subjected to the sexual harassment is going to face some kind of issue at work. They might get fired, they might lose a promotion, they might not get a raise, that kind of thing. And a hostile work environment is a supervisor, a coworker, even a non-employee interfering with someone's work performance. So vendors coming in and being inappropriate with employees can be considered sexual harassment. Sexual harassment can go between coworkers, or it can go obviously between supervisors and employees. It can also be, well, let me give you an example. A few years ago, I was called to investigate a claim of sexual harassment by several women or female workers in a nonprofit, very similar to this. And the supervisor wasn't doing anything that was one-on-one or quid pro quo sexual harassment, but he was doing things like standing in their doorways, women's offices' doorways, and not letting them leave without rubbing up against him. He would do things like ask about their weekend activities with their boyfriends. He would sit in meetings, and I just remember this as a specific example. He would joke with people's chairs and, you know, the little flips that make the chairs go up and down. He would all of a sudden make somebody's chair go down. So his behavior was quasi-sexual in nature, but it was very inappropriate for a supervisor to be doing these kinds of things. So that would fall under a hostile work environment. So does anybody have questions about what that can mean?
Does it only pertain to supervisors? Can it be a peer?
It can be a peer, coworker, a friend. It can apply to things like stalking. We don't really use fax machines anymore, but emails being sent inappropriately to one or more people in the workplace. A hostile work environment can be very broad in definition, but we're going to talk a little bit more about sexual harassment in this form. But yes, it can be same-sex people, girls harassing girls, men harassing men. So it used to be where, appropriately, we have the next slide, most of sexual harassment was male and female, male supervisors to female subordinates. But the Supreme Court has opened that up tremendously because so many situations were being brought before the Supreme Court that were not just male supervisors and female employees. So right now, the Supreme Court doesn't care. The courts don't care. Sexual harassment can go on between anyone. There is some confusion about sexual harassment versus other kinds of discriminatory activities. So when you talk about sexual harassment, it has to be sexual in nature. So the comments, the touching, the jokes, the stalking has to have a sexual meaning behind them for the courts to look at sexual harassment. It has to be unwelcome, and we'll talk about that in a minute. What does that mean? It has to be unreasonably offensive. And the Supreme Court came out with a reasonable person standard several years ago. And we'll talk about that in more detail in a minute. It must be severe or pervasive. And this is the one that's very difficult, and that's why I'm here today, is employers knew or should have known that this was going on, and they did not take action against what was happening. So now, in 1986, when sexual harassment was actually legally clarified and defined, the courts were inundated with claims. And so as time went on, the courts had to set up some boundaries around what really constitutes sexual harassment and what doesn't. So one of the things they said was it has to be unwelcome in the eye of the beholder. So something may be offensive to me or to you, but may not be offensive to Vivian. So a group of people may be joking and having fun, and the jokes may be sexual in nature, and some people are not going to be offended by that, and some people are going to be offended by that. So when companies put policies together around dealing with sexual harassment, they don't have a choice anymore but to put together this type of training and policy, because I don't know what might be offensive to you. So you have to assume that everyone might be offended by something, maybe not all at once, but that people will be offended. Does that make sense? Okay. The conduct is unwelcome when it is unsolicited, the employee has done nothing to incite it, and when the employee views the conduct as undesirable or offensive. So, what does that mean? If I ask someone out on a date, for example, that by most standards would not be unreasonably offensive or unwelcome. But if I kept asking somebody out on a date after I've been told no, then that can become unwelcome. Okay? So if somebody is a jokester and they're a fun person and they tell sexually oriented jokes, you know, the first time may not be unwelcome. But if it continues, then it can become unwelcome. Okay, so unreasonably offensive. When a supervisor demands sexual favors in exchange for getting a raise or promotion, we've talked about that. Once an employee has set the boundaries of what is personally offensive, so long as the boundary is not unrealistic, it may become sexual harassment for a coworker, for example, to continue to cross those boundaries.
Question?
Yes.
So, for example, if I ask someone out and they refuse to say no, that would qualify in that category?
That can, yep. Yep.
What if I said to you, I like your sweater? Is that offensive?
No.
It looks good on you or something like that. I'm just trying to compliment you. Depends how you take it. It sounds like what you're saying.
Yes.
Right?
Now, we've all known people that are great complimenters. So they will say to everyone, wow, you look great today. You look great today. You look fabulous. Have you lost some weight? I mean, we all know people like that. So once in a while, that is not going to constitute sexual harassment. But if somebody tells you every day, or all the time that you look beautiful today. You've lost, wow, you look fabulous. You know, what are you doing to your, I mean, after a while, that may become unreasonable and unreasonably offensive. Okay? So, that's why the courts have said realistic. And they've also said reasonable person standard. So, we'll talk about that in a minute. But what would a reasonable person consider as offensive? Is that clear? Pretty clear? Okay. This is not by any means black and white, let me tell you. When you have to try to defend some of these things or investigate some of these claims, it is anything but black and white. So, okay, when something creates an abusive work environment. I don't know, a few years ago there was a landmark class action lawsuit by employees of Mitsubishi Motors. And the women claimed they were on the floor making cars. And the women finally claimed that they had been subjected to years of abusive behavior by male counterparts on the floor. And abusive was anything from verbal criticism, verbal, very inappropriate language, calling female coworkers you can imagine, touching them, harassing them, taking their tools, and finally they sued the corporation. And the case was actually settled, and what was settled was never published. But that's the kind of abusive thing to an extreme. But if things like that are going on around you or anywhere near you or to a friend or coworker, then that's going to be considered abusive. And it was not a single or isolated incident. So again, asking someone out on a date is not going to be considered sexual harassment.
So
Repeated.
Can ask someone out for a date. Says no, if she says no, or he says no, or whatever. That doesn't mean that, and that's not prevented. Preventable life. It should not be something that the administration would say you can't, supervisor cannot do.
We've read it, that's here.
Yeah, but I was going to get to whether it's a policy or not. No, I'm just.
Mm-hmm.
It's not okay. There's no stated policy in. Would it be okay for a supervisor to ask someone under his or her charge for a date at one time?
Well, let's put it this way. Is it appropriate for the work situation? You know, relationships go on in workplaces all the time. So some companies say very clearly that is not allowed. So it's not allowed. If somebody asks somebody out on a date, is that going to result in a charge of sexual harassment against the employer? Probably not. But if it continued for a long period of time, then that's when it starts to become sexual harassment. Okay. Vivian, if you want to jump in here anytime.
Well, one of the things that we talk about is that it's not really necessary for the employee to decide what it is. All they need to decide is that they're uncomfortable
Mm-hmm.
and that they should come and talk to somebody if they're not happy about something.
Okay.
And let us decide if it is or isn't. Or they can decide and go on their own to the ERC, but we prefer to come back first so we have a chance to fix it.
Sure. And we'll talk about that too. Okay. The reasonableness standard. The courts have established the reasonable person standard. It's gone from reasonable woman to now reasonable person. And this means that would the conduct be offensive to a reasonable person? We've all met somebody who, you know, they're maybe hypersensitive to things. There's nothing wrong with that, but in terms of what we're talking about, would it be offensive to a reasonable person? Okay, what is severe and pervasive? What is the nature of the harassment? Is it verbal, physical, both? What is the frequency? Did it happen once? Did it happen 50 times? What is the duration of the harassment? Did it happen for a week, or was this ongoing? In the instance of my supervisor, this had been going on for months. And what is the context? Is it to one person, which is sort of more along the lines of quid pro quo kinds of things, or does it happen to a lot of people? Okay, what is not severe and pervasive? A joke here and there, being asked out on a date, an occasional reference as babe or honey. I worked for a mortgage company, and the founder of the mortgage company was 80-some years old, and he called everybody baby. So it was just who he was and how he addressed people. So a sexually explicit item like a picture, a statue, something that may or may not be considered severe or pervasive. It depends, but. Okay, why do companies have to worry about sexual harassment? There is a law called the Civil Rights Act of 1991, and I'll talk about what that means. Civil lawsuits can result in millions of dollars in damages, and just the workplace ramifications and consequences of harassment. The Civil Rights Act of 1991 basically allows a plaintiff, if a plaintiff wins a charge against an employer, it may result in back pay, front pay, attorney's fees, reinstatement, and punitive damages, which means the court can say, you know, this was so obnoxious that we're going to punish you by awarding that plaintiff X amount of money. So it can be extremely costly. Never mind what it does to the workplace and the people involved.
So if a sexual harassment complaint is made, it's against both the offender and the company.
Mm-hmm.
And both are culpable. It sounds like the company loses if the perpetrator stays on the job. If the company pays the job to the victim, but the perpetrator, there's a possibility that might maintain his job.
Possibly, unlikely, but possibly. It depends on the situation. Usually when something has gone that far, they would not be employed. But you can imagine the disruption to you and your fellow workers by having this occur. So again, the courts have said to employers, here's what you need to do. You need to have a policy, you need to do training, you need to have a complaint procedure, and we'll talk in a minute about your responsibilities in terms of what you need to do if you feel like you've been subjected to sexual harassment. Juries tend to side with the plaintiffs, so you rarely want a case to go to a jury trial. Most cases do settle out of court. One case that I was involved with was at actually the mortgage company, and unbeknownst to me, we were closing an office in Denver, and so we had one female employee working out of that office, and unbeknownst to me, she and the president of the company had been having an affair for a few months. They would travel together to Arizona. He bought her jewelry. They were smoking marijuana. I knew none of this. We went in to tell her that we were closing the office and we were letting her go. And she popped up within 2 seconds and said, "This is because I'm not sleeping with you anymore." So you can imagine how I felt, thinking, oh my gosh. And she proceeded to give us a litany of things and issues, and that actually did settle out of court. It cost the company about $125,000. That's what I knew of. So very, very nasty, very ugly situation. I'll tell you another story in a minute. But it's terrible and it's terrifying. And not only were we out the $125,000, we were out the legal fees and attorneys' fees for defending a company against sexual harassment can run $500,000 very easily. So it was a very nasty situation.
Out of curiosity, was the CEO terminated?
No. No. I know, president of the company, it can happen. Okay, the employer knew or should have known. What this means is the courts just really don't condone employers allowing sexual harassment to go on in their workplace. So they assume that the employer knew about it, or they should have known about it, and they should have dealt with it. And that gets pretty tricky because sometimes we don't always know things, just like I didn't know that that was going on. So it makes it very difficult when that is going on and then all of a sudden it comes to light that this has happened. So again, we have to publish the policy. I'm sure it's in your handbook. And okay, we have to train employees. We must investigate. So even though you might feel like you can come to an HR person and say, "This is what's been happening, but I don't want you to do anything about it. I don't want you to tell anybody." We can't do that anymore. We have to investigate every claim of sexual harassment. And the employer will try very hard to keep it as confidential as possible. But sometimes, if there are a lot of people involved or that have to be interviewed, you can imagine that doesn't always work out that well. So it's better for us to just say, "Don't do it up front, please," than to have to backtrack and investigate it from there on. Okay, we talked about this. The quid pro quo cases are very often he said, she said, she said, she said. Very difficult to prove. And the courts basically say, "Sorry, employer, if you let this happen, you're going to pay for it. You're going to write the check. There's nothing you can do, really, to defend it." In hostile work environments, those cases get a lot more tricky. A lot more people know about it. A lot more people are involved. A lot more people have been privy to whatever's going on. Even though you say, oh, I don't want anybody to know about this. So it's better, again, for us to just say, we don't do that. Sexual harassment, again, we as employers are responsible for clients, customers, vendors, coworkers, visitors. So if the UPS guy is coming in every other day and he's sitting around and hanging around and he's asking the receptionist out on a date every other day and bringing her chocolates and treats, we have a responsibility to stop that.
It's unwelcome.
If it's unwelcome. Yes, we're going to talk about how we're going to know that. Okay, what happens when a supervisor or a manager starts to have feelings for, and we all know people who've had relationships in the workplace, starts to have feelings for a subordinate. Sexual favoritism can occur. That person gets the raise and no one else does. That person gets promoted and no one else does. The psychological harm of workplace relationships that go bad. How many of you don't have to raise your hands, but have known of a couple in the workplace and they break up and then all of a sudden they don't get along. Somebody's denied a promotion. Somebody's telling everybody, well, this is what so-and-so did. The morale goes bad. Same-gender harassment is on the rise. As you can imagine, it's no different. Okay, when are employers most liable? When we know that something's going on, we know that so-and-so and so-and-so are seeing each other, and they're in a supervisory subordinate relationship, and we allow it to go on, that's when we're liable, very liable. When a company doesn't investigate a claim, again, we are required to investigate claims. When a company allows sexual harassment and discrimination to continue. Over the past couple of years, because sexual harassment is considered discriminatory, and I don't know if your handbook has lumped all of discriminatory acts together under one complaint procedure, but now any form of discrimination, sexual, racial, ethnic, religious, anything is really to be, if someone has an issue, they need to follow the same complaint procedure. So it isn't just sexual harassment anymore. Any questions about?
I have a comment.
Yes.
I had a staff member make a complaint that would not give me names, and I couldn't investigate. And I asked that person to think it over and come back and talk to me, and still did not want to give me the names. So, I tried to get some hints from her, and couldn't get anything. So if you want to make a complaint, you need to have names. You need to know who it is that's abusing you, I guess.
Yes, because if you feel that you have been subjected to some kind of harassment or discrimination, and you leave the employer, and you maybe went to HR and said, yeah, but don't tell anybody, and then you try to file with the EEOC. The EEOC is going to most likely say, did you report it? To whom? Did you follow your procedure? And if you didn't, they are most likely not going to take your case. So you have an obligation to tell the employer now. What had happened when sexual harassment really got a lot of attention starting in 1986 is people didn't do anything about it. They left, and then unbeknownst to the employer, this had been going on, and the employer wasn't able to do anything about it. So really, the courts want the employer to take action. They want the employer to address this. They don't want to have to deal with these cases unless the employer hasn't done anything about it. Unless you truly have done what you need to do and then the employer hasn't done anything. Then you have a case. But they want you to take as much responsibility as an employee for this as the employer. So what does that mean? You need to follow the complaint procedure that Vivian has set up. You have to cooperate with the investigation. You must give names if there are names. And let the employer figure this out and deal with it. And most employers will deal with it. Now, it can mean that somebody may lose their job. It may mean that somebody gets transferred to another department or building or something. There may be consequences. But again, sexual harassment is illegal. So we have to treat it as such. The cost of sexual harassment, low morale, lack of trust. If you know of a supervisor who's having an affair with a subordinate, there's a lack of credibility, a lack of trust. The morale is impacted. Polarization between departments or teams, turnover, all kinds of things. Not to mention ruined reputations and careers. That can happen. So, oh, I'm sorry. I thought, okay. Erase IN2L. Follow the policy, report any claim of sexual harassment, even if you're not the one being victimized by it. If you see it, you have an obligation. Management will investigate. It may be management on site. It may be calling in somebody to do it, to keep it as objective as possible. No retaliation can occur. So if you report it, then nothing can happen to you. You can't lose your job. You can't be forced to work in conditions that are less than what you've been working in. You can't be harassed. You can't be denied promotions. So no retaliation can occur. And appropriate employee action will occur. So again, somebody may lose their job. We have to investigate. We've already talked about that. We have to interview all the witnesses. Okay, I think I've gone over that. All right. Vivian or whomever will report back. They have an obligation to report back to the person who's complaining. They may not give details, and probably that's appropriate. Although if it results in somebody's termination, then that would be obvious, but they're not required to tell you everything that has occurred. There may need to be consideration of damage control, so that's always difficult because you really don't know sometimes what the fallout is of that. Okay, what is your responsibility? If somebody is harassing you or doing things that are inappropriate, in your opinion, or offensive, you need to step up and tell that person, this is not okay here. This is offensive to me. It may not be to Joe or Mary, but it's offensive. And it's affecting how I'm working. It's affecting my job. You have a responsibility to do that. Document your interaction. If you have reported it, make a note of when you did that. Sometimes these things take a while to actually get investigated, and dates and things are always helpful because we don't always remember. Follow your company's complaint procedure, and I assume that's published. Cooperate with the investigation. Again, we have to do this, so your cooperation is very much appreciated. And never let it continue because you think nothing will happen, nothing will change, or something bad is going to happen to you. And lastly, before I tell you my story, questions? Anybody have questions? Okay. Common misconceptions about sexual harassment. That it's obvious and blatant. It is almost guaranteed to be anything but. And it doesn't usually get bad until a relationship goes sour. You know, everything is fine, and then boom, it didn't work out, and the one employee decides, you know what, this is harassment, which is what happened to the mortgage company. We had every justification in the world to let her go, but because it was all this other stuff was going on, it turned into a lawsuit and keeping her on board and all kinds of things that were very difficult for the company. That one incident constitutes sexual harassment. Now, I'm not saying that one act of violence or violent kinds of harassment wouldn't, but by and large, one joke or one date request is not sexual harassment. That all inappropriate behavior constitutes sexual harassment. Remember, for it to be sexual harassment, it needs to be sexual in nature, etc., etc. It doesn't mean that it's not some other form of harassment. But I get that a lot where people say, well, this is a hostile work environment. And under the sexual harassment umbrella, it may or may not be. But it doesn't mean that the behavior isn't inappropriate. That suing a company is easy. It is terribly difficult on you, the company, everyone else. It can take years of your life if it isn't dealt with immediately and appropriately. And I heard a statistic the other day, which I had not heard before, but that if your salary isn't $40,000 or above, attorneys aren't even going to look at you. So it behooves everyone to just deal with it when it occurs. Thoughts? Questions? Okay, I'll tell you my story. I was working at a company that was a nonprofit organization. This was about 12 years ago. And this company, one of their branches was in Los Angeles, and their sole purpose for that office was to protect animals in the film industry. So they hired film reps. And what you may or may not know, and I'm not even sure if they're still doing this, which I heard an interesting thing today. I can talk about that in a minute. But at that time, they hired film reps. Anytime any animal is used in a movie, on a film set, on a television show, even on the variety shows, Jay Leno, they have to have a film rep representing the animal to make sure that it is not injured. So the director of that office, who happened to be a woman, hired a female attorney. And she was sent on site to a rather famous film. I think I can talk about it now. It was The Horse Whisperer. And she actually had an affair while on site with the animal trainer. Now, I did not know any of this. And so immediately our role as an agency and as film reps were compromised, because what is she there to do? She's there to protect the animals, the horses, and she was sleeping with the animal trainer, who happened to be a very famous animal trainer. So this had gone on for a little while. Well, I got called out there to do some training, just like I did today. And all of a sudden, their film reps came up to me and started telling me about this situation, because they were being confronted on other movie sets and shows by other animal trainers saying, you know, why are you here? You don't have to be here anymore, because you're already compromising your position with our animals. So I'm thinking, oh my goodness. Well, long story short, we did the training, but the damage had already been done. And the director was about ready to lose her job, because she had allowed this to go on and fester for months. And it wasn't a true quid pro quo case of sexual harassment, but the film reps were getting hassled on the film sets, and so it became a hostile work environment situation. So she fired the assistant director in retaliation of all of this happening, and she was allowed to keep her job for a little while it was being investigated, until the CBS Nightly News got a hold of the story, and then she was fired. And of course, the media, national news, I was called by an investigative reporter. It was probably the ugliest situation I've ever been involved with. And it was all because the director didn't deal with the issue immediately and promptly. No one did. And as you can see, it was horrible. Their whole concern was keeping the contract with the film industry, because that's obviously a very prestigious thing to do. But I heard this morning that PETA had gotten involved with the HBO show Luck or something, that they just canceled because 3 horses have died filming this series or whatever. So I don't know if they kept the contract or not. PETA may have it now. But anyway, so that's my story. That's how bad it can be. I can't think of too many more situations that could be worse. So with that, I'll conclude my training. If you have any questions, thoughts. Yes.
Traditionally, when you see a movie or a television show, it's almost always a male supervisor harassing a female. Okay? I'm sure that's changed in the workplace, right, over time. And I'm sure it doesn't matter which sex is harassing who, but is that going to change in the media? Because that's just not factual anymore, I would think. It doesn't really matter. Harassment is harassment, as you're pointing out, right?
Right. The courts have just basically said, you know what, it doesn't matter who it's between. We think of it as the male supervisor and the female secretary, but the courts have had so many cases come before them where it's anything but that.
And I'm assuming probably more often than not, it's 2 people on the same level, co-workers. Right? You don't have to be that supervisor for there to be harassment, correct?
Right. And, you know, when the courts came back, when they said with tangible job detriment. So a coworker can't always, and usually won't, influence whether the coworker gets a promotion or not. But it can certainly turn into a very harassing situation, an uncomfortable situation. There have been cases of stalkers, a relationship gone bad, then all of a sudden one employee is stalking the other employee. Those have been considered sexual harassment. There was one case, and I don't have all the details, but it was a case of a group of men working on an oil refinery in the Gulf. And it was a new person who'd gone on to the oil rig, and these men were doing everything sexual in nature to abuse this kid. It was a kid. And he sued, and it made it all the way to the Supreme Court. And that was really a pivotal case, because then the court just said, you know what, it doesn't matter. If your employees are doing this to other employees, this is sexual harassment. But again, it has to be sexual in nature and all that kind of stuff. But anything else is going to fall under that hostile work environment. And so as employers, our best defense is we just don't go there. We just don't even want employees to think that this is in any way okay. Okay. Well, thank you very much. And I'll be here for a couple minutes if anybody has anything they want to talk about. You're welcome.